Welcome to episode 2 of Your Cup of Counsel, Law Talk Served Hot. Today, we're talking about all things money. And we're drinking delicious baseline coffee from Oakland, California, that we both thoroughly enjoyed drinking and highly recommend. I hope that you'll comment, like, subscribe, review, all the things so that we can know what you want to learn about and talk about it. Thanks for being here and talk to you soon. Hello, and welcome to episode 2 of Your Cup of Counsel, Law Talk Served Hot. And Anjay, today we thought we'd talk about money, all things money. What money can you expect to get in a lawsuit? What kind of money does your lawyer get paid? How the heck are the money numbers that are in all those large headlines actually true? And how do the plaintiffs in those cases get those huge, high millions of dollars of numbers? All things money. And it's a little different between the personal injury and the employment space, but there are a lot of similarities. So, why don't we start with you telling us how money damages are figured out in the personal injury space? If a client comes to you and says, I had this horrible thing happen to me or a family member, what can that client expect to get paid on the case?
So you've asked me the question that usually happens in the first conversation with all clients. And I always tell them, this is not a question I can answer on our first meeting. It's really the most complex question, I think, of the entire case. But I do like to tell people there are certain things that we're looking for when we're determining what case value is. It's usually way too early to figure out what that number is going to be in the beginning of the case. And even at the end of the case, like sometimes we'll get into a jury situation if it's a case that hasn't resolved. We're putting on evidence at trial. We think we know what the case is worth, but we don't actually come to the exact number that we're going to ask for until all the evidence is in and we've evaluated the witnesses and we've kind of read the room to see what the jury is feeling. And then you come up with the ultimate number that you're going to ask for. But it can be all over the map. And I have conversations really early on with clients about what their expectations are, what their desires are. And then there's all kinds of different buckets of damages, right? There's like medical expenses, property damage, and then there's non-economic damages, which is just a legal word for like damages to the person. So loss of enjoyment of life, grief, sorrow, inconvenience, kind of the less hardline numbers, we'll call them.
And so it's true that when you say you don't know what the damages are, it's because you're thinking about what the non-economic emotional damages are and should be and what you should be asking for, right? Because I can see the questions coming in, right? People are saying, well, property damage and medical expenses, those are hard numbers. Like I get a bill and I pay that. So that can't be a number that you don't know what to ask a jury for or that you don't know what to tell your client to expect. But what you're talking about is the damage, the emotional distress, the number that's sufficient to compensate somebody for the emotional hardship they've suffered or the pain and suffering through an injury or that sort of non-quantifiable number, right?
Absolutely. And I love that you picked up on that because, and that was me just not really answering the question correctly because I have this assumption in my mind that in all of my cases, which I think is true, the non-economic number is a multiplier of the hardline numbers.
Higher.
Because I have death cases, catastrophic injury cases, where the damage to the person, to their quality of life is going to greatly exceed the medical bills, the property damage numbers. And so for me, those numbers tend to be not small numbers, but numbers that I'm not paying as close attention to. I'm working on what's the narrative, what's the story for the larger bucket.
For how to tell the jury what your client suffered from an emotional perspective as a result of the injury and also the way that their life has changed, I would imagine, right?
Exactly. Yeah.
And when somebody comes to you, well, why don't you explain to us what the buckets are? So what are those big categories of monetary damages that you go after in these cases and like yeah, what types of monetary harm and what are the buckets?
Yeah,
What are the major
absolutely.
buckets?
So there's two. There's economic harm and non-economic harm. So economic, like you said, those are the hardline numbers. Those are your medical bills, your physical therapy bills, your receipts, your parking, your mileage, your property damage, your wage loss. I lost 6 months at work. This is what I was earning. This is the replacement. If you have a diminished capacity, so I can go back to work, but I can only work 30 hours instead of 40 because I fatigue or I need accommodations, those will all get factored out by economists and vocational experts. And those are your economic losses. So there's a dollar value, there's either a receipt or a projected value that you can tell the jury this is the loss. And then the second bucket, non economic harm, there is no receipt. There isn't an amount that you've already paid to somebody. It's not money that's going to get sent to a physical therapist or a psychiatrist. That's just to compensate the person for the diminished capacity that is their quality of life, or a shortened life expectancy. So now I'm only going to live to age 45 because I've, gotten some disease from some work exposure. And so what's the value to me that now I only have 15 years left instead of potentially 30 or 40 to see my grandkids graduate college? Like those are the numbers and the stories that we're developing in the non-economic category that I think take a lot of time to develop and a lot of time to understand your client to really kind of tease out where the real harm is.
And probably also a way to tell the story to a jury that fairly captures it, right? Because, uh, like you said, I mean, we have a really messed up justice system in a lot of ways, and one of those ways is trying to put dollars to something that is not at all quantifiable, and that's so difficult to value. And but money is all we have. Like as lawyers, that's the only quote unquote justice we can get for our clients is to compensate them using money, which is a really powerful thing, can be a very powerful thing, but also is so hard to put dollars to, because how do you put a monetary amount to losing, in my case, with my practice area, like losing your sense of dignity in the workplace, that feeling of being discriminated against in an area where all you want to do and all you expect is to be treated as an equal. That's such a difficult thing to put words around, never mind dollars or ask a jury for dollars, right? So
So how do the damages work then in the employment side?
so we have non-economic damages and economic damages as well. The economic damages are calculated based in a wrongful termination case, I have a client who was fired, and we call back pay the amount of lost wages that client suffers from the date of their termination until the date of any eventual judgment in the case. So assuming a jury trial takes, let's say, 2 years from the date of filing, or the date of termination, my client would be entitled to 2 years of lost compensation. And it's not just wages, it's stock options, equity. Stock options is a little bit nuanced, but the total loss in terms of their compensation. So commissions, bonuses, benefits, all of it, um, up until the date of judgment. And then front pay is from the date of judgment looking into the future. Front pay is a little bit more speculative because every client who has been fired has a duty to mitigate their damages. What does that mean? It means if you're fired for a bad reason, you can't sit on your couch and eat potato chips. You need to go out and try and find a job. And the law only seeks to make you whole. So once you find a job, any income that you get from that second job is deducted from your total damages award. So same as you, I could have a situation where my client has almost no economic damages because most of my clients are extremely talented and competent people, and they were able to get a job right away, and they are earning either the same or sometimes a little bit more than what they were in their past jobs. So a lot of my cases have lower economic value, but the emotional distress that my clients have suffered in the workplace is massive. And there's a lot of very unique reasons for that in the employment context. Largely people's identity is really tied up in their jobs and their sense of self and their sense of self-esteem and the stress and pressure of, you know, providing for their family and paying their mortgage or their rent. And that adds other elements. And you spend more time at work than anything else, really. So if you're being consistently harassed or discriminated against or unable to do your job for reasons that have to do with your gender or your race or these things, it really has a major impact on your sense of self, especially if it's a triggering event from something else that's happened in your past and that kind of thing. So very similar to you, we have to do a really careful job of telling our clients stories and explaining why the racist conduct they've experienced has really emotionally impacted them. And we do that probably similarly to you through therapist records if our clients have gone to therapy. And we can talk about all of the ways that we prove it. But those are the major buckets.
Okay.
And in employment cases as well, um, attorney's fees are also provided separately. So what that means for folks who have not had to go through the legal process before is instead of you as a client, as a plaintiff, paying for your attorneys out of your own recovery, which we'll talk about in a moment. Um, in my cases, if we prevail in trial, the company that we're suing actually separately pays the attorney's fees, and that's a huge benefit for our clients as well. So there's a few different buckets.
Okay, let me ask you this, and I don't know the answer. You're talking about when we go to trial, we can get attorney's fees. Do all cases go to trial? Do a lot of cases settle? And do the fees get handled differently if it's a settlement versus a trial?
Great question. 95% of cases settle, probably more than that, and especially in the employment context. Um, and trial is actually also different in the employment context. A lot of people, when they first start a job, sign a bunch of papers. And in those papers, there's usually an agreement to do what's called arbitrate your claims. It's an arbitration agreement that takes away your right to a jury trial. And most people sign that not knowing what it is, or if they do know what it is, they don't think they can ever negotiate it, which is also something we should spend a whole podcast topic on because I feel very strongly about our constitutional right to a jury trial and the fact that we should have it and it should be preserved and it's really important. And arbitration is something that favors companies more than plaintiffs, in my view. So some cases go to arbitration instead of trial, but nonetheless, 95%, if not more, cases settle. When it comes to attorneys' fees that are representing plaintiffs, the vast majority of them in the employment space are paid by a contingent agreement, which means a percentage of whatever the client, the plaintiff themselves recovers in the case. So it means if I'm a client, I don't pay my attorney hourly, which helps in my case because my clients have just been fired, so they don't have a lot of cash flow. And the firm and the lawyer will front all the costs, but knowing that at the end, whatever pot of money I'm able to recover in the case, a portion of that has to pay for costs and a portion has to pay for my attorney's fees. In the employment context, if we try our case and we win, like I said, the company will have to be required to pay the attorney's fees separately. If the question that I think you're asking, which is one that I get a lot, is, well, what happens to the attorney's fees if we settle? In my experience, when we're trying to resolve a case, you're usually just resolving for one pot of money. So when I'm communicating with my client and when we're in those settlement discussions, all of us are on the same page that whatever pot of money we are going to get, the final total settlement sum, that a portion of that is going to come out of for attorney's fees, and that's partly because a defendant, in my experience, a company kind of has trouble wrapping their head around also paying an attorney separately, and there can be weird questions about how much that attorney's worked and what their hourly rate is and all of that. So usually attorney's fees aren't paid separately in a settlement.
Okay.
But
So very similar to personal injury.
yeah, tell
Same.
me about how it works.
Yeah. So we work on contingency fee base. So we don't get any money unless we recover for the client. Case costs come out of whatever pot of money there is as well. So one pot of money, case costs come out, attorney's fees come out. So it sounds like the settlement scenario for employment is the everyday scenario for PI.
Interesting. And do you think, I don't think this is a controversial thing to say, but I usually tell people if you have a claim, whether it's an employment or a PI, a personal injury claim, and you're looking for a lawyer and the lawyer tries to charge you hourly, or has an exorbitant fee split where they're taking like more than 50% of your fee or something like that, that's a red flag and that you should definitely seek a second opinion from an attorney if you find yourself in a situation like that, because the industry standard is contingent fee arrangements when it comes to plaintiff's work.
Yeah, I think that's right. I'm sure again every fact pattern is different, every situation is different. I'm sure there's some situations where, it's a quick case, it's a couple hours of attorney work and so maybe an hourly makes sense. But the cases that I'm handling, the cases that you're handling, I agree. I don't think any of that would make sense on an hourly basis. And also, the really, I think, neat thing and the reason that the system is set up this way on a contingency fee basis is so that everyone has access to attorneys. Everyone has access to the courtroom. If there was an entry to a barrier to entry, thank you, to getting a lawyer, to filing your case, then we would have less cases and people, mostly low-income people, would be the ones that are underserved.
Yep.
So it kind of levels the playing field for everyone. Everyone has access to a lawyer. Lawyer has to hustle and do their job because they only get paid if they do so. And so it just kind of keeps the whole system honest.
Yep. I totally agree with that. And I guess the only caveat in the employment space is that I have seen some lawyers charge hourly to do like severance negotiations.
Mm.
And that's, usually if there's a very clear understanding between the client and the lawyer that this is a limited scope piece of work that we're going to do. And because the numbers maybe are so high that it wouldn't make sense or be fair to the client to take a large percentage of that number if all we're going to do is a bit of a negotiation. It's a very different thing than if you're taking a case through to trial for 2 years or something.
Yeah.
So like you said, it's always nuanced, everything. And frankly, most of what we're saying on this podcast is nuanced, and we're giving you kind of our general view based on our experience and what we've seen. I think we've been really lucky to work with some really excellent lawyers, and Anjay and I both came from amazing firms that taught us really well. And we've been blessed to have really great training, but we're not, speaking the Bible words here, and there's lots of different interpretations to the law, particularly. So like with all things, you should get a second opinion about everything.
Yeah.
But yeah, that's our
What about
experience.
when you call in first time? Like all the law firm websites say free consultation. What is involved in a free consultation? And do you ever feel like people maybe abuse that or try and get free legal advice? Or can you review this contract on our free consultation?
Yes.
Like, how do you politely tell people what the limits are on the free consultation?
Yes, this is still something I'm struggling with to this day. So full disclosure, because I just want to help everyone all the time. And a lot of times, I think I've mentioned this in our earlier episode that I talk myself out of a job a lot. And every employment case is very nuanced, and it is a minimum 30-minute conversation usually, just because there's so many details and facts, and people are really upset and often somewhat traumatized by what they've been through and very stressed out. And I think that it's my obligation to help people understand what their rights are. So I often spend time, speaking with people about all of these things. But I always do free calls. And I think again, this is another red flag, green flag situation. I think most plaintiff attorneys will speak with you for free in the beginning. If you're needing to pay $1,500 for an hour of a lawyer's time, I can tell you, you don't need to pay that. You can find lawyers who will do that for you for free. But generally, what helps me a lot is if somebody emails me a timeline of events before I do a call with them. And that's because in employment cases, it's really critical for me to see the dates that certain things happen, because we spend a lot of time building a circumstantial case using circumstantial evidence, which we can talk about what that means. But looking at the relationships between different events and the relationships between the timing of things is like the most important thing in employment cases. And so I'll give you an example of what I'm talking about. If I have a whistleblowing case and my client reported something that they thought was unlawful in the workplace and they're fired the next day, that's a really important time relationship. And the law actually says that we get an inference of retaliation when there's close, they call it temporal proximity. So when there's two events that happen close in time, we get an inference, which is like a slight advantage to proving our case, because it's logical, right? If you look at a cause and effect of one thing and another thing, seeing those types of relationships is really important. So when I talk to a client at the beginning, I always say, nobody knows your situation more than you do. And I need you, because your memory also is the most fresh it's going to be now than it's ever going to be. It's only going downhill from here, right? That's how the human brain works. So sit down, write down dates and witnesses and every single thing that you can remember that's happened, and give that to me so that I can review it and start to piece together some relationships of things. And then that really kind of helps guide our conversation.
Yeah.
What about you?
So one thing you just said that I think would be really helpful for our listeners,
Yes.
I wanted to flag it. And I think can be a source of frustration for some people is sometimes you call a law firm and you don't get a lawyer. You get an intake clerk or an intake specialist or somebody on the front end that's gathering information, and they tell you, I'm going to send this on to an attorney. And what I want our listeners to know is that is part of the process. And it's not you getting punted down the road. It's because that specialist knows how to tease out the really important information that the attorney needs so that they can have an efficient and meaningful conversation with you.
Yep.
If you're doing if the free consultation call is just gathering information, attorneys can't be on the phone all day with potential clients. Our phone rings all the time with potential clients. And so it's a way for us to make sure that we're getting the key information that we need on the case to have a meaningful conversation during the free consultation so we can tell people, yes, you have a case. No, you don't have a case. Or maybe you have a case, but I'm not the right lawyer for you. You can tell me more on employment, but I know for me in personal injury, there are certain cases that I handle and certain cases that I don't. Like I don't do personally a lot of medical malpractice cases. So you may have been catastrophically injured. If it's in a hospital environment, I'll talk to you. I can help you like tease out, what questions, what information we need to send you to the right place, but I'm not going to be the right lawyer for you. And that's all part of the process. And so I want the listeners to know, don't get frustrated if you get routed to an intake clerk, but also there are some red flags. If you only ever get to an intake clerk and it's, 9 calls and you still haven't talked to a lawyer, you're probably stuck in one of those high volume call center type situations where you just need to move on and see if you can talk to a real human.
Yeah, no, it's such a good point. So glad you raised that because yes, I do not spend all of my time talking to potential clients. I talk to folks who have already gone through our intake process and make their way to me. And frankly, you and I are both similar in this. Like our goal is just to help as many people as we possibly can. And I can't help as many people as I possibly can if I'm taking every single intake call, right? So there has to be some scale there, and that's why we have those structures built in there.
Yeah.
Mm-hmm. So when someone calls you and says, I need you to tell me how much my case is worth so that I know if it's worthwhile to take. And you say, I can't tell you because it's too early and I need to evaluate a lot. How do you really decide with someone whether it's a case worth taking and whether, as you said, it's worth going through all of the stress and burden and all of that associated with a lawsuit?
Yeah. So some cases are pretty cut and dry. You'll know right away. It's a death. They were T-boned, somebody ran a red light. It's a product that collapsed. We've had a bicycle case where somebody was cycling and the handlebars came off, detached. It was like a failure in the metal. Those kinds of cases, you're like, okay, there's clearly a product issue. Somebody's in a wheelchair. Somebody's life has forever been changed. That's a no-brainer. That's going to be a high value case. That's a case that I'm going to add value to. I'm going to sign up that client and we're going to figure out what the number is, but I can tell them it's worth pursuing. We can't guarantee results. We never can. Ethically, we're not allowed to do that. So I never tell someone it's a slam dunk. We're going to get $1 million in your case. But I can tell them, I do think that you have a lawful case. I think you have a claim. You've got a viable defendant. You've got a well-known entity on the other side, or this is an insured loss. It makes sense for you to pursue this path. Sometimes I get calls from clients where, something really unfortunate happened. They already know because they've been called by the other driver's insurance, and there's only like a $15,000 policy, which before January of this year was the minimum auto insurance coverage in California, which is insane, which hadn't been changed since like the 1970s. Doesn't even cover like a visit to the emergency room these days. So luckily those limits have been changed. Still, I think grossly low in California, but better since January. But in a case like that, where someone calls, I know the injuries exceed the 15,000, there's not going to be a lot of other coverage for them. I'll tell them, you can make that call and get that money yourself. Like you don't need to pay a lawyer to do that. I'll help steer them in the right direction. And they don't need to be kind of cannibalized by an attorney fee coming out of such a small pot when I know the harm is really more than, unfortunately, what they're able to recover.
Yeah. I mean, oh gosh, I have that conversation all the time too. That I think there's a deep sense of being wronged when somebody has been fired. And I totally understand that. And because again, it really strikes to the heart of their identity and especially people that work really hard at their job and try to be the best they can possibly be. Right. And I totally understand that. But there's what happens in the real world that we experience. And then there's what happens and what we can prove in the court world and in trial. Right. And getting evidence in an employment case is very challenging because when an employment claim case begins, when it starts, we are at an immediate disadvantage because we don't have any of the evidence. And all of the evidence is held by the defendant and by the company because when you're fired, you're locked out of the system. You don't have access to your email. The witnesses who saw everything are still working at the company. So they're going to be under the control of the company's lawyers. And it's my job to really fight tooth and nail through the discovery process to get every shred of documentary evidence and depose the witnesses who are going to be defended by the company's lawyers and still figure out a way to get the testimony we need. And so it really is a challenge. And that's why I say it's not as easy as just filing a lawsuit and then getting paid. There's a lot of work in the meantime and a lot of work that has to go into the intake process to make sure that everybody is on board with that big lift, right? That on both sides, on the client side and on my side. And so a lot of times clients will call me and say, here's all of this stuff that happened. And I'll say, it's going to be very, very hard for us to prove that what you're saying happened, and it may not rise to the level of a legal claim. But here's what I would say. I don't think that the way they terminated you was necessarily fair. And a lot of times there's wiggle room to negotiate your own severance. So, go back to them and try that. And here's an understanding of what your legal rights are, but you don't need a lawyer. And same, you don't need to pay somebody a percentage of whatever that bump you might get in your severance pay. And it probably also is not worth the hardship for you in litigating this, right? And this is something that reasonable minds will differ on. I think if that same client maybe walked into another lawyer's office and that lawyer saw, a different way to litigate the case maybe than I did, then all the power to them. But I like to say that I'm in the practice of being a civil rights lawyer and civil rights in the workplace. And I want to take cases that are meaningful and impactful both to my client, but to what that case represents, right? That we're standing up for the underdog. We're standing up for a basic sense of decency in the workplace. And if I don't get that feeling too from a case, then I don't think it's worth my while because that's my purpose on this earth. And there are a lot, like we've all said, there's a lot of lawyers out there that will do different types of cases, right? So yeah, those are some of the things. But I think in general, we're both saying the same thing, which is don't walk into litigation lightly. It's a big decision to be made. And you need a lawyer that's going to really carefully look at your situation and be straight with you about what it is, right?
I tell clients all the time, I'm going to be upfront with you. And if at any point in the process, we get to a point where the case value is not high enough for this to be worth the emotional load and the time investment and everything for you, I will tell you. I'm not going to spend my time and my money chasing something that's not meaningful for either of us. So you need someone, though, that's going to be paying attention to your case and doing that analysis and giving you real-time advice.
Because you would want that too, right? I mean,
Absolutely.
I would want that. I would want my lawyer to say, this was a good idea and now it's not anymore.
Right. Right.
Or whatever,
Right.
whatever the case may be.
Or we've got a settlement offer on the table. Could we hold out for more? Yes. Is it worth another year and a half litigation, additional emotional investment for a client that really just needs to put this behind them to move forward? Sometimes you take a discount on the case value because there's other non-monetary aspects that really carry a lot of weight.
Yeah, absolutely. I've definitely had those conversations. What do you think about these massive multi-million-dollar verdicts that we see in the headlines? This is the episode about money. So I think we should talk a little bit about either debunking some of the myths that come along with those humongous verdicts, and probably also calling out the really negative stereotype that it gives a lot of plaintiff lawyers are about being money hungry and ambulance chasing and all the things we've heard many, many times.
Yeah.
What are your thoughts?
So many thoughts. We could do an entire hour-long episode just on media blowing up large verdicts, debunking what a large verdict is and what it isn't. I think there's so much disinformation, like all areas of life, right? Across the board. There's the truth, there's the half-truths, and then there's the media spin. And I think when you get big verdicts, that's what draws media attention. And then people start talking about things that they don't really know. They didn't educate themselves. Like, for example, the McDonald's hot coffee verdict.
The classic example.
I can tell you pretty much every single time I've picked a jury, it comes up for discussion. I'll ask a general question to the panel. Who thinks that there's runaway verdicts, or verdicts are bad for society, or verdicts drive up insurance rates, some general question, somebody inevitably every single time will say, well, did you see that lady that sued and got billions of dollars from McDonald's? I'm like, okay, first of all, it was not billions of dollars. It was reduced post judgment. All kinds of reasons that statement is wrong.
And her injuries were egregious, right?
Egregious. Yes, absolutely. And so before any of our viewers want to comment or have a dialogue on the McDonald's hot coffee case, I would encourage them to watch the documentary. They did a documentary on the case itself, analyzing the injuries, the horrific treatment that this poor woman had to undergo, and what was going on the coffee side, what the manufacturer warnings had been on coffee temperatures, how McDonald's wasn't following them, all of that. Like, educate yourself before you share a strong opinion. But the McDonald's hot coffee case,
Amen, sister. Amen.
the McDonald's coffee case comes up all the time in voir dire. And I really, obviously, this is what I do for a living. I trust the jury system. I think 12 members of the community more often get it right than they don't get it right. And so if I see a big verdict in the headline, I think to myself, that person's in a bad way. And that jury did what's just and awarded them fair and full value for whatever the harm is. And if it's a $10 million verdict, it was probably a $10 million harm. If it's a $1 billion verdict, it was probably a $1 billion bucket of harm. Or it's a punitive damage case where, maybe the verdict headline doesn't totally tell a picture. Maybe the plaintiff only got $7 million, but then there was a punitive damage where the company knew, they hid, they misled, they were doing all of this really bad conduct. And so the jury's punishing them so that they right the ship, so that they don't do that to consumers going forward. So a verdict can have, is super powerful on a corporate bad actor in changing bad conduct. And so we as society should really encourage big verdicts so that we're holding people accountable, and, companies aren't taking advantage of people by saving 10 cents on a bolt that's going to fail. Little things like that. I think if people really educated themselves on the nature of the case where there is in fact a big verdict, they would feel better about the numbers that are being given to
I
plaintiffs.
totally agree. And maybe let's break this down a little bit, because what you said is so true. And I just want everyone to really understand it. So we've been talking a lot about the money that a client can get in a case, right? We're talking about damages for emotional distress, or my case is back pay or medical expenses, those kinds of things. And those are really sought to compensate the victim of the harm, right? Punitive damages are different. And punitive damages are also really misunderstood, I think, across the board. Um, but the point of punitive damages is, like you said, to punish bad conduct, like particularly bad conduct, right? So not just conduct that causes the plaintiff harm, which we've already covered, but we're talking now about really intentional, malicious, fraudulent, oppressive, right? Those are the words that we have to prove if we're going to seek those damages. And the point is to send a message to the corporate bad actor that this can't happen again. So it's a message of deterrence, right? And so I think my view of these big verdicts is that it's very, as you point out, it's very hard to see how those big verdicts are broken out. But when you see what buckets of money those big verdicts come from, it makes a lot more sense. So, for example, there's been a couple like $230 million employment cases. It's a single plaintiff. So one person is getting a $230 million award. And I get a lot of questions about that. There's been a couple of them recently, and I actually know the plaintiff lawyers who did those cases, and I've, learned all about them. But most of those cases have pretty huge punitive damages awards. And what does that tell us? It says, as you point out, the jury was sitting in that courtroom and saw a bunch of evidence of either a cover-up on like a massive scale, or egregious wrongdoing, like knowing that there's bad conduct and then doubling down on that bad conduct somehow by either further victimizing the plaintiff, or like I said, covering it up or keeping it from law enforcement, or like the conduct that really should be punished if we're going to send a message, right? And that accountability is so important, like you said, because otherwise, I mean, there's so many huge companies in our world with so much power. And if they don't get told by the very important jury system that what they're doing needs to stop, a company that's huge and is making billions and billions of dollars is not going to take a message seriously unless
It hurts.
It hurts,
It has
right?
to hurt.
It
Yeah.
has to, they have to feel the pain. Like
Yeah.
if I'm Elon Musk and I'm driving down the street and I get a parking ticket and I get hit with a $10,000 ticket, if I, Tamara Prevo, get a $10,000 ticket, like I'm going to feel that pain. Is Elon Musk going to feel the pain? No, he's not going to care. And so
Yeah.
that's the whole kind of reasoning around punitive damages award,
Yeah.
why it matters so much.
And also, I think people don't know that haven't been involved in a case that the jury hears financial information. So the jury is going to have context for the number. So I've seen some attorneys in a punitive damage phase of a case, they'll say, I'm asking for $100 million because $100 million is Nike's profits every minute or something. They'll tie it to what the company's profits are. So it's not just some amorphous number. They're not bankrupting these companies for the most part. It's a number tied to their profit structure. It's a number that's going to hurt enough that hopefully they'll change bad behavior. But generally, it's not going to bankrupt these companies.
And the other important point I think we should also raise is, because I'm sure we get potential clients asking this question too. Do you think my case is a $230 million case? Do I have the chance to do? And I think if you haven't picked up the message already, what we really want to drive home is that knowing whether there's enough evidence to support a huge punitive damages verdict takes an entire case to develop and figure out, right? And so really, like, we can't answer that, and we don't even know what we're going to ask the jury for, because we need to see every shred of evidence to see what we could even support to get to the very end. And the verdicts that we hear about in the headlines are pretty rare. We're not spinning off $230 million verdicts like all the time, right? It's egregious, really, really bad misconduct that is being covered kind of in those cases. So don't expect that every case is going to be massive. On that note, I realized that we haven't even talked about our coffee that we're drinking.
What are we having for episode 2?
Episode 2 is baseline coffee, or as Anjay said, baseline coffee. Sorry to out you. And this is in Oakland. And it says it has notes of root beer, cocoa nibs, and it is robust. What do we think?
I thought it was great.
I thought it was great.
Yeah.
What do you think could be improved? My French press skills?
So again, I think we haven't quite mastered the French press. And I think the temperature of our water has not been warm enough because I like my coffee a little hotter.
Okay, well, you know what? That's why we have 100 million episodes to practice our technique on.
Exactly.
So let's not stress out about that. We'll get it right at some point. I do think we're nicely caffeinated, though.
Definitely.
I feel like we were talking a little fast, maybe.
Could be. We'll find out by our comments and followers.
Yeah, I mean, luckily there's no court reporter in the room. No one has to type this up, but otherwise we'll get by. Well, thank you for joining us on another episode of Your Cup of Counsel. And hopefully episode 3 will get our coffee ratio right.
Let's chat. Cheers.
Cheers.